members of the competition agency. When I joined the ICA back in 1995, actually he was already there. He was a young senior official, which is very difficult to be young.
My hair were black.
Young and senior. And then from remote we have Alberto Bacchiega. Alberto is director of the Directorate in charge of media, telecommunication, and he's been around in DigiCom for many, many years. He's a great expert of antitrust, mergers, state aids. We actually worked together at the time. It was in 2003 when he joined the merger task force. Actually, I was given the task to introduce him to DG competition. So as you can see, although it doesn't look like, he's actually younger than me. And then we have Tim Lamb. Tim is the head of the antitrust for the EMEA region in Meta, and he is younger than me, as you can see. So now, coming to the format, okay, so we have decided not to give monologues or presentations. We're going to have hopefully a lively discussion around a number of topics, few macro topics that we have selected. I guess that the audience is very knowledgeable. Perhaps just to set the stage, let me very briefly remind what the DMA is about and how it will work. Very briefly, in 3 minutes, so scope of the DMA. It is a piece of regulation, as you know, which imposes a number of obligations and prohibitions to tech companies providing these so-called core platform services, acting as gatekeepers. The goal of the DMA is supposed to be to protect fairness and contestability. Bear in mind this, because this is a very important point, which is a cause of concern, as you will see in a second. Then what actually are the core platform services which are caught by the DMA? So we have an exhaustive list, I think, of 10 CPS. So you have online intermediation services, so Amazon Marketplace, and then you have search engine like Google, the social network, Facebook, and then the browser. And then the instant messaging, WhatsApp, and others. So who qualifies as a gatekeeper? So according to the DMA, there are 3 qualitative criteria which are presumed to be fulfilled, right? If there are, if a number of quantitative thresholds are met. So in essence, you have an impact on the internal market, which is supposed to be met if the CPS makes more than 7.5 billion in the preceding year and 75 billion of capitalization in at least 3 countries of the EU. Then there is a second criterion, is it must be an important gateway for business users, right, to reach end users, which is presumed to be fulfilled if there are at least 45 monthly end users and at least 10,000 yearly business users. And finally, the CPS has to have an entrenched and durable position, meaning for at least 3 years, these quantitative thresholds that I mentioned have to be fulfilled. So what is the process of, for designation of gatekeeper? It is a speedy process. So the CPS meeting these criteria, okay, so qualifying as gatekeepers are supposed to notify within, I think, 2 months of satisfying these requirements to the European Commission, which is in turn has 45 days to designate, so to take the decision, of designation as gatekeepers, right? And then what are the obligations and prohibitions applicable to the gatekeepers? There are a number, there's a wide array of, prohibitions and obligations, some of which have been, of course, taken inspiration from the recent EU Commission enforcement practice, like self-preferencing, like tying and then you have the parity clause, for instance, and then, okay, you have a number of obligations like to provide the interoperability, portability, obligation to provide front ends to the data, and obligation to provide data access to business users and others. So I think my last point, just bear in mind that who actually is going to enforce this DMA, it's very simple. I'm afraid Andrea is going to be the Commission. So Commission, the sole actually responsible, with the national competition agencies playing a relatively limited role. Of course, in the enforcement phase, the Commission can actually impose fines up to 10% of the turnover of the companies, 20% for the repeat offenders, and then even in case of a systematic failure, non-compliance, there are also behavioral and structural remedies. Now, having said all that, and against this background, I propose we start, and my first question would be to Alberto. Alberto, perhaps you can tell us, so, let's discuss a little bit the process, okay? So the designation process. How will it work in practice? Can you tell us more to begin with, about the internal mechanic? How is it going to work? Because we understand from the press there will be, a new task force, DG Comp, DG Connect, under the responsibility of 2 commissioners, possibly newly recruited officials. And this designation process, how is it going to work in practice? Is there really room to, resist, oppose, or argue that despite these criteria, the presumption can be rebutted? Please, Alberto.
Okay, thank you, and good afternoon to everyone. So Mario already recalled the main step in the designation procedure, when actually the clock will start ticking is not yet set, but it will be very soon. It will be at the moment of the publication of the DMA in the official journal, which we expect by mid-October, more or less. And then there will be technical times that Mario recalled, so the notification obligation from the gatekeepers we expect will kick in sometime next spring. Let's say late April, more or less. And then they will have the 2 months to notify. As you mentioned, we will have 45 days to take the designation decision. So the process is very clear. How it will work, probably is worth saying how it is working, because even though it looks far away, it's awfully close. And it's, we said publicly, and we started the dialogue with all the prospective potential gatekeepers who actually want to talk to us already before the summer, this spring, because once the text was stable of the regulation, it was in everyone's interest to start this dialogue. So there is a dialogue ongoing. As you mentioned, is the Commission enforcing? Within the Commission, there are 2 departments, DGs in the lead, which is DG Comp and DG Connect. Obviously, the 2 DGs that are closest to where there is the most expertise to deal with the regulation. Of course, the legal service will, as always, play a very important role as well. And but I think one thing that is important to us is that to the outside there will be the Commission, and everybody who comes to talk to us meets a case team, and we will have, in a sense, a very traditional type of organization by company, by topic, and a clear allocation of responsibility. There will be one place where to send the document. There will be one interface towards the companies outside.
Right. And perhaps to Tim. Tim, what is your sense of this designation process? I mean, how are you living this in your company? Are you doing your homework already? And so how does it work? And what are your fears? What are your concerns?
Thanks, Mario. So yes, obviously we're doing our homework. We're obviously engaging as Alberto has flagged. I think the reality is, when you look at the way that the DMA is drafted in this respect, what it has given rise to is a debate around how far the regulatory proposal actually takes us away from competition law. And I know that part of the debate, part of the concerns raised are that these proposals and the way the gatekeeper designation process is constructed is highly deterministic in relation to digital markets and leads to a presumption of bad outcomes if a company reaches a certain size, and that's by reference to sort of monthly active users, turnover, market cap, etc. And so you do see concerns that these metrics are being used as a proxy to indicate whether there's a problematic situation which may trigger intervention. And so in the public debate, you are seeing a lot of those concerns raised. And the concerns are linked to whether there's potentially an oversimplification of digital economics, or whether the DMA itself, in the way it's constructed, in the way the core platform service process is constructed, and the way it's identified, actually could lead to a dampening of competition in certain areas. But I actually, rather than fears, you might say that there's potentially some hope, at least from my side. We'll have to see if it bears out, and there's a lot of things to assess as you move forward with the new law. But there are openings to suggest that actually, even in the gatekeeper designation process and the delineation of core platform services, there's an opening for a greater contextualization around the notion of market power. And that's perhaps because, at least in the DMA, there's one of the core aims that we're all talking about is this notion of market contestability. And that suggests that to the extent that a core platform service triggers potentially some of the metrics and some of the thresholds set out in the DMA, there may be openings to have, and it's a question at this point, an evidence-based position where you look into whether the service is actually an important gateway for business users to reach end users, and whether that service actually has an entrenched and durable position. There's question as to how that rebuttal process will work, but at least in the DMA there is an opening for potentially that kind of discussion to take place based on evidence-based sort of submissions.
Right, indeed. Perhaps to Andrea, I mean, this is a very delicate question, so let's discuss briefly the role of national competition agencies in the DMA enforcement. So this is within the scope, okay, of the DMA. We know that Commission is going to be the sole enforcer, in principle, but NCAs, they have a role there. And how do you see this role? Because, you know, they can do inspection, they can do investigation, even of their own initiative, but there are limits. So how do you think it is going to play? Is it going to be sufficient for the national competition agencies? The Italian agency has been, as you know, extremely active now in this space over the last years. In 2021, I think you did as many as 4, 1 or 2 investigations, and then other cases of unfair commercial practice. So it's an authority which is eager to, you know, intervene in this area.
Before starting, I would like to thank, Jones Day for inviting me, and Lear for the organization of the festival. And just replying to what at the beginning Mario said, that I have to be afraid that there is just a residual role for the National Competition Authority. I can add that, don't be afraid, don't be sorry, because I think that it's quite reasonable centralized process to deal with a supranational phenomenon like the ones raised by digital platforms, or to be more fashionable, gatekeepers, in order to define just a particular kind of platforms. But I might be really tempted, even though Mario has already set the table, I would be really tempted to add something, just to say something about the context. But let's say the train has already started, so I think it doesn't seem to me particularly useful to emphasize the potential weaknesses of the new tool, the pros and cons. At least I hope that we share, I assume that we share some points. For instance, I mean, digital platforms raise quite complex challenges that affect competition, but also privacy, pluralism, and even democracy. I mean, just the last session concerned the interplay between privacy and competition and antitrust, and we just realized that it's not that easy, the dialogue between antitrust agencies and privacy agencies. I mean, the different culture, we have to converge, but I mean, the convergence process is not that particularly, it's not so easy. I think that, I mean, after 10 years, let's say, of under-enforcement, I think that we have to do something, especially as far as merger control is concerned, but something has to be done. I think that the Digital Market Act is supposed to be the main tool that can make it possible. So I think that this could be a common knowledge, at least among us. I mean, the mantra of the Digital Market Act, of the debate concerning the Digital Market Act, was quick and a timely response. That was, I mean, and because, I mean, the new tool has supposed to be a self-enforcing one, a self-executing one. I'm not that sure that such a self-enforcement is so quick, is so timely, but I mean, we hope so, because, I mean, starting from the designation process, even though, as Alberto stated, I mean, it has already started, but I'm pretty sure that there will be a debate among the platforms and the supposed gatekeepers. And I think that since, I mean, the Digital Market Act privileged a one-size-fits-all approach, I think that the fewer the gatekeepers, the lower the risks to make mistakes, and the lower the risk to reduce in an injustifiable way the scope for the application of antitrust. I mean, shifting to the question, the direct question that Mario asked about the parallel role of the national competition authorities, I think that, I mean, first of all, we have to decide if the authority will be the antitrust one, because, I mean, since the final version of the Digital Market Act is clearly a compromise at the political level, there are still some gray zones. And for instance, in one part of the regulation, it is clear that the role will be played by national competition authorities, and the other part, the regulation says that the authority which will be designed by the member state. So it's still formally open to roles played by other agencies. But I mean, I think that there are two main points. The first one is that, I mean, who is the authority who will take part in the advisory committee? Secondly, there might be a role at the national level for the application of the DMA just in the investigative phase, investigation, but afterwards the final decision will be up to the European Commission. I think that carrying out the investigation and leaving the final part of the proceeding to the European Commission might be controversial, but still may be quite useful. And even from the perspective of the national competition authorities, cannot be reduced to a mere ancillary role. Once you have investigated, I mean, you can play your role. And I mean, and don't forget, and this is the second part of the question, that national competition authorities may enforce national provisions, so platform-specific prohibitions, as in the case of the recently amended German competition law, and national laws on economic dependence as the new powers, the new provisions which affect the Italian competition law. And I think I would like to stress this one, because, I mean, we should know that the two main goals of the Digital Market Act are contestability and fairness, whatever it means. I mean, fairness is a fantastic term. It's not easy to translate it in Italian, but I mean, it might mean almost everything. And in economic terms, I mean, this morning we discussed about the role that could be played of economic analysis in competition law, and it is quite clear that economics is not just efficiency, and not static efficiency, but fairness is very difficult to handle, and it has to be handled with care. But as far as fairness is concerned, the abuse of economic dependence might play an important role, because it is clearly a tool aimed at dealing with fairness among firms, business to business, but at least it's clearly focused on that tool. So I think that a parallel application of this tool, consistent with the application of the Digital Market Act, could be useful also for the European Commission. I think that we can leave it for the second round of the questions. I think that all this, I mean, requires a very high degree of collaboration. I mean, cooperation among national competition authorities, European Commission, and other agencies, privacy agents, the regulatory institutions like the regulatory authorities. I mean, it's very, very useful. I mean, I can say something about that because, I mean, the Italian Competition Authority directly experimented at the different level what collaboration means. I mean, we strictly collaborated with Alberto and the civil servants of the European Commission when we dealt with important cases concerning digital platforms, like the Amazon case, the Amazon Apple case, the Google NLX cases. I mean, I almost fell in love with Thomas Crumbler because we called every day. We had a very strict relationship, and I think that it was a very useful one. I mean, we also experimented, and it was much more, let's say, challenging, to use a sort of British understatement, the collaboration with the regulatory bodies, the Telecommunication Regulation Agency and the Privacy Agency during the sector inquiry concerning big data. And I think the different cultures, I mean, are different, but they have to cooperate and converge because, I mean, these, the challenges raised by the digital world concerned all these different aspects. But I want to stop here.
No, I think, I mean, I agree with you that we need cooperation. But just if we focus first on the situations where actually the national competition agencies have to act and operate within the scope of the DMA. And then we discuss what happens outside the scope, because in my view there is a big difference there. So within the scope, and perhaps Alberto can actually give us his view, I see a potential problem, because you mentioned this hybrid case. According to the DMA, the National Competition Agency can open an investigation on its own initiative regarding violation, non-compliance with the obligations and prohibitions of Article 5 and 6 of the DMA. So you can do actually an investigation. Problem is that the Commission is indeed, at the end of the day, the sole enforcer. So it's like you have to bring the case to the Commission, and my question is how it's going to work. So actually the companies which is being investigated has to interact with the National Competition Agency, then with the Commission, we both at the same time. How does it work? Alberto, how does it work?
But we'll see this part as we go along. I think I couldn't agree more with Andrea. The key and the really important aspect here is to continue collaborating and discussing openly between the Commission and the national competition authorities. And it's true there is the potential for a clash if we don't collaborate openly, but there is also the potential of reaping out the many synergies between the authorities if we do it well. How it works, the National Competition Authority can work together with the Commission in the investigation phase of any case under the DMA. Of course, it cannot be in isolation, it needs to be in a coordinated way, and it needs to be in a way that preserve the right of defense of the parties. I don't see this as impossible. It's a challenge, but it's very possible. There is already a system of coordination for the application of antitrust rule and Article 102 under the European Competition Network, and that's something that we want to greatly leverage also for the application of the DMA. It's obviously not for the Commission to tell member states which authority in particular should be appointed to take up a certain role under the DMA. That's for them. But clearly, from the point of view of DG Comp, we have a very powerful tool where we are used to collaborating, and that we can leverage further to collaborate also in the application of the DMA.
Right. Timo, what is your sense there? So we discussed, so the case would be, so within the scope of the DMA, kind of hybrid investigation, handled in parallel or simultaneously actually by one or more national competition agencies that decide to investigate, and then they have to interact with the Commission, perhaps with the Commission taking the lead. So I see it as a nightmare, to be honest with you, but please.
I think it's encouraging, obviously, to hear Andrea and Alberto both talk about close coordination and cooperation and information sharing. I think that's going to be key, sort of in ensuring that when there are queries and when there are investigations into certain products and services, there is a focus on the potential for alignment of outcomes. Because fundamentally at its heart, the DMA is an EU regulation, and its aim is driven by the desire for a harmonization of rules, at least in terms of the application of the DMA itself. And so when you look at the construct of Article 1 of the DMA and how authorities are supposed to can run investigations, they ultimately have to coordinate that with the Commission. And that must be in the aim of ensuring a harmonization of outcomes across the board. And as a company with services that are inherently cross-border in nature, that is important to many of the tech companies that are under discussion in relation to the DMA. And so the hope is that harmonization comes through as a result of the coordination and close cooperation that's being discussed today.
Right, okay. All right, now if, a case run in parallel simultaneously, jointly by the Commission and the NCA may prove to be a monster case, then within the scope of the DMA. Now, if we go outside the scope of the DMA and then we discuss the interplay between the application of the DMA and conventional antitrust enforcement, then in my view, we face an even bigger risk of, fragmentation, overlap, over-enforcement, because it's pretty clear, based on the DMA preamble, that the DMA is actually aimed, as I said at the beginning, at protecting fairness and contestability, and this would not, correspond with actually the legal interest protected by EU competition rules, domestic competition rules, and what have you, which means that clearly NCAs can investigate cases in parallel, which are very similar, and therefore the risk of overlap is important. Andrea, you told us already, but to be more concrete, because it would be cooperation, that is important, but we would not be, here there would not be a preemption principle, so the Commission cannot, impose.
No. I mean, the DMA is not my favorite tool. It's not perfect, but don't make it more complicated than it is. I mean, first of all, there is the early warning whenever we are interested in something, in launching an investigation. So, I mean, just at the very beginning of our curiosity, we have to talk with the, we have to and we want to talk with the European Commission. So there is a high degree of cooperation since the very beginning. And I think that in the near future, it will be very, very rare that there will be an overlap between the investigation at the national level and an investigation launched by the European Commission or the DG Comp or whatever. I think that there will be coordination since the very beginning. I mean, in order to be concrete, I mean, in the vacuum of the DMA, because I mean the DMA is not yet fully working. I mean, we recently launched a new investigation concerning Google and Hoda, and the main issue, the main concern of the investigation is interoperability of personal data, which is fully in the do's and don'ts of the Article 5 and 6, whatever they mean, because I mean, I forgot we didn't have time to discuss about the list of Article 5 or 6, because I mean, when you say self-preferencing, what are you saying exactly? I mean, is it so clear? I'm not sure it's that clear. So, I mean, but in that case, interoperability and obstacles to interoperability are clearly a matter which is interesting for the DMA. But I mean, we discussed the launching of the new investigation with the European Commission, so we could start it in the vacuum in these 2 years, and afterwards we'll do the same. The early warning is crucial. I mean, both from the perspective of the National Competition Authority and from the European Commission, it's absolutely useless, and I would say frustrating, to work when somebody is going to overlap. I mean, the main goal, I think that the main goal at this time should be to avoid the fragmentation of the legal framework of the Digital Market Act. I mean, once the train has finally started, this is the main goal. It will be a chaos if there were, for the lawyers, for the firms, and also for the agencies, if there will be parallel investigation using abuse of economic dependence, unfair practices, consumer protection, all of them focusing on the same matter. I mean, neither of them will be extremely popular in the near future in this case. But I think it's quite easy, if there is goodwill, to avoid it.
Right. No, I think it's good. I mean, we are, I guess, reassured that there are safeguards. So our enforcers believe in the safeguards of the system, which is I think is a positive note. By the way, regarding the nebis in idem that you mentioned, right? Do we all agree that it doesn't bring us very far? No, this B-post case law, because on one hand is this new principle of the ECJ jurisprudence. Setting up a kind of lower threshold to trigger the bis in idem. So only identity of persons and identity of facts, no more the legal interest. But then that jurisprudence, set forth a number of caveats which actually correspond very much to the situation of the interplay of the DMA with the rest of the standard antitrust provisions, meaning that probably, I don't know, Tim, do you have regarding this B-post case law, do you think that it can help? Because my impression is that it cannot help when it comes to the interplay between the DMA and Article 102 or another domestic provision?
Right, so one of the carve-outs seems to be where you have an Article 102 investigation and then a parallel sector regulation regime. And I think what this is going to go to is, again, some of the potential crossover between the different regulatory instruments that are being introduced or that have been introduced over the past 5 years. And so when we talk about close coordination, when we talk about cooperation, it's pretty clear, and as Andrea said, that it's not limited just to the competition authorities and with the DMA. It also stretches into the data protection authorities. It also stretches into the implementation of the Digital Services Act, where there are potentially obligations across all those instruments that aren't exactly complementary. In fact, you could see that each of those instruments tends to serve potentially different aims. And so at some point we're going to have to reconcile those different aims, because at the moment we risk becoming entangled in a web of potentially contradictory obligations. And for companies to navigate that, it is going to be exceptionally difficult if there isn't sort of live discussion between the different regulatory authorities. And that does include the data protection authorities, and I know there's the AG opinion from yesterday, which everyone is studying and is quite nuanced in its approach. But I think that level of coordination and forethought is going to be essential and critical when it comes to the alignment of outcomes. And it's essential because many of the DMA obligations that you have listed in Articles 5 and 6 actually reference the GDPR, actually go back to concepts that are developed under the GDPR. And at some point there is a risk when you have a number of different authorities opining on a similar concept that you have different interpretations of that concept, whether that be GDPR consent or other bases, there's the potential for that to happen. And I think given the DMA especially goes into issues around core product design, which are essential to the way users actually interact with the services, and it's why the services themselves are so popular in the first place, they're so easy to use. That coordination is going to become critical. And that's because, again, these services, these products are cross-border in nature. And if you start to tweak with product design in one jurisdiction or under one regulatory regime, and then a different regulatory regime or a different jurisdiction comes to a slightly different conclusion, the viability of the solutions that we would all be working towards becomes highly questionable. And I think that is going to become a real issue that we have to get our head around over the next few years. And so the question is, for me, the question is, how can companies help regulators sort of navigate that web of different obligations? And fundamentally, we're just going to have to move into a new regulatory space, a new regulatory culture, where we engage much more with the authorities in terms of product design. And I think we would be happy in some instances to have joint meetings with the authorities. And we should think about creative solutions that enable easier discussion and more transparent discussion around some of the issues that we're going to face in Europe. Otherwise, I think the complementarity and potentially otherwise of some of the obligations that we're facing will call into question some of the laudable aims that exist within the DMA.
Right. Yeah, I think you're making a very fair point. And actually picking up on the last point that you make, perhaps this to Alberto and Andrea, of course, both of you. So in a way, you know, the adoption of this DMA marks as well, you know, a kind of revolution, right? And perhaps will actually put in motion, you know, a profound change of the relationship between you know, these tech companies and the enforcers regulators, no? So there will be perhaps need for a dialogue along the lines of what happens in other regulated sectors, you know, more you know, like we have seen in the telecom sectors, for instance. So is there, do you see, Alberto and Andrea, do you see over the time you know, an evolution of the relationship? Because so far there has been a lot of confrontation. So, yeah, probably as Tim said, now, you know, things have to change.
But Yes, probably this is the case. I think you made a good parallel, Mario, between what is happening to the digital sector and the introduction of regulation is a revolution for the sector, but it's not a revolution in absolute. And maybe at last also this sector joins the panoply of other sectors of the economy that are regulated and are subject to competition rules as well. So maybe there is also something to learn from the interaction between regulation and antitrust enforcement and competition enforcement in other sectors. It's not always easy, but certainly it's possible. On the, let's say, on the attitude, on the whether it's a confrontational relationship between the enforcer or the regulator and the business community and the companies, I think it depends a lot on the process and depends a lot on the instrument. And even within competition enforcement, it's true, one can say it's a very confrontational instrument, that's in the nature of it. But if you think, discussion on how to optimize remedies is much less confrontational between the enforcer and the parties than, discussions that are preceding a prohibition. So what I want to say that the DMA, by its nature, is prescriptive and doesn't want to open to a discussion of the extent that takes place under competition enforcement. Is much less refined in its in its methodology. There is no talk about market definition, no talk about dominance. It's a completely different mindset, but it's also a mindset where companies are required to say how they will comply with the regulation, and they should have the means of receiving feedback from the Commission on whether what they intend to do is in line with the regulation. So I think the onus is on the gatekeepers to respect, but the responsibility is also on the Commission and the collaboration with the national competition authorities actually to be proactive and in collaborating and also understanding and taking into account the requirements in terms of resources that the changes will bring in order to find a solution. That part needs to be a part of collaboration. There will be also a part of monitoring and perhaps sanctioning. And there, I don't have much illusion that if we ever, we have to get there, and I hope not, it will be very confrontational.
Right. Andrea.
Okay, I think that the introduction of the Digital Markets Act is a radical change. I don't know if it is a revolution, but it is really a radical change. And I think in this perspective, as Alberto said, that the dialogue with the companies in order to make it work as well as possible, it will be key in the near future. If I may add, my main concern is strictly linked with the debate that took place this morning in the opening section about the so-called more economic approach, the role of economic analysis. I think my fear is that economic analysis may be dismissed, not only in the application of the Digital Market Act, but as a radical change in the competition culture. I am afraid of something that could be said, could be defined, the so-called per se temptation. And whenever there is a temptation, somewhere there is a sin.
All right. I think it's a great conclusion. And let me perhaps ask the floor whether there are any questions. Is there anyone, does anyone want? Please. That gentleman over there. Hai il microfono. Question is coming. Cannot hear you very well.
Hello? No? Yes.
Please.
Okay, yes. This is Tonohin from MLEX. I had a question for Alberto, and it relates to the budget of the DMA. There's been a lot of discussion on whether there's enough budget to hire more staff, or how the commission is gonna get more budget to get the appropriate resources for all these gigantic tasks that is the enforcement of the DMA. Could you enlighten us on how is it going and how the commission is planning to get more resources?
Right. Alberto, it's for you. So in fact, they want to know whether you have the budget, the money to finance, to fund...
Who is going to pay? At the end of the day, it's the typical question.
So the macro answer is that the Commission has had a zero growth policy now for a number of years. So that mobilizing additional resources within the Commission is not easy, so it's really a matter of prioritization. We have budgeted in the regulation 80 people, full-time equivalent for the implementation of the DMA. This was in the Commission proposal. Actually, the scope of the DMA was enlarged during the discussion in Parliament and Council, so probably we will need more than that. We are not in a situation where resources fall easily from the sky, but of course this is a priority of the Commission. What we've been doing so far is to leveraging a lot the synergies we have, in particular, at least in DG Comp and where I work, with antitrust work.
Are you heading toward the...
Continue doing. We are eagerly awaiting the reinforcement that should come, and there is also a ramp up to the needs,
right,
which was also in the accompanying part of the regulation, and now it's already quite intense because the dialogue has started. Next year we will need to take the designation decisions. Early 2024 we will have specification decision, we will have monitoring and many other activities.
All right. Okay. All right. So do we have other comments or questions, team, Andrea, Alberto, or no? All right, if there are no further questions, so let me thank our speakers who did great, and of course the audience. Thank you very much, and I wish you a very good rest of the day. Thank you.
Thank you, goodbye.
Thank you. Goodbye.
Thank you very much, Alberto and team.